Dear all, today let us discuss one problem under administrative law with regard to the transfer of certain criminal cases to some other court. Here, probably it is a quite common thing that certain category of cases which can be transferred to some other special courts or fast track courts like that. So let us go to the problem. Here problem states that state X established special courts under statute for the purpose of speedier trial. Some cases were transferred to the special courts from regular criminal courts. Yes, whose case has been transferred challenges its legality. Will he succeed? So, this is the problem. That means, here certain category of cases has been transferred to the special courts from regular criminal courts. Here, yes, he challenges with regard to the transfer of the courts, transfer of the cases from the regular criminal court where his case was initiated, because he thinks that this sort of the transfer is a arbitrary one, unreasonable one, it is a discriminatory one. So he thinks like that, and he thinks that it is against to the due process of law, because what happens here, his case was initiated before the some regular criminal court, and all of a sudden that cases has been transferred to the special court. Here, yes, he challenges the thing. He challenges the statute where his case was transferred to the special court with regard to the discriminatory the character of the statute. So let us go into this problem, how to solve this problem. Here I used to tell you that here with regard to this one we have to follow issue, rule, analysis, conclusion method, so that we can get the correct answer. If we follow this method, we can get the correct answer. So, first of all, we have to frame the issue. On the basis of the facts, we have to frame the issue. Here, how the issue has to be framed? That is, it should be in the questioning sentence. Here, whether the yes, so otherwise you can take whether the transfer of yes criminal case from a regular court to a special court established under a statute for the purpose of ensuring speedier justice or speedier trial is legally valid. That means you can form the question anyway. You can form like this also, whether it violates the yes fundamental rights under Article 14 and Article 21 of the Indian Constitution. As I told you, Article 14 gives the emphasis with regard to the equality, right to equality. That means equality before law and equal protection of law. So that aspect yes is challenging. And under Article 21, we can think that it is with regard to the right to fair trial and due process of law. So you can frame the issues depending upon the problem which is given to you. So this is the very it is the it is a brain work of the lawyer and brain work of the law student. Then we should go to the rule of law, or what the law will say. Here we have to consider this aspect, because depending upon the rule of law or provision of law, we have to discuss. Here, no doubt, Yash's case has been transferred to some special court from the regular criminal court. But what is the idea behind it? What is the objective behind it? What is the intelligible differentiation there? That means, what is the rational basis for this one? Here they have made the classification as according to the famous saying of the Constitution. That is Constitution. What it under Constitution, we know that Article 14 permits reasonable classification and prohibits class legislation. That means here also the classification has been made. That means the cases, Yesh's case, that means the petitioner's case, he may be accused, but he has filed the petition before the High Court for challenging the said transfer. Here, what happens? It is whether it is a reasonable classification or not, because all sorts of the criminal cases cannot be transferred. Only certain category of cases can be transferred. Certain category of the criminal cases can be transferred. Here, what the other side respondent has to show, if it is whether they have done the classification, whether it is based on the reasonable classification, and whether it has got any nexus with regard to the objective, that is whether there is any element of intelligible differentia, whether is there any rational relation. So here that aspect, what you call, the respondent has to prove that here under rule the Constitution of India provides the following key protections. Article 14 ensures equality before the law, prohibits arbitrary classification. So here we have to see whether it is a arbitrary classification or it is a reasonable classification. Only one thing we have to establish, whether it is a arbitrary classification or reasonable classification. Here arbitrary classification means here they will not notify that the transfer of the cases from certain court to other court. The public intimation has not been given. That is the due process of law. That is what is established under the law. They have to follow. That means the prior notice has been given and it should be declared in the newspaper. And if there is any what you call objections are there, they can call for the objections. So, if it involves the rational relationship between the reasonable classification and the objective which is to be achieved. What is the objective? Objective is to achieve the speedy justice. So, if that is there, said transfer, we cannot say it is illegal. That is a permissible one. Here, under Article 21, it guarantees the right to life and personal liberty. No doubt, Yesh's life, he may challenge the said transfer under Article 14 and 21. But it also includes under Article 21, the Article 21 which says that right to a fair and speedy trial. That aspect is included under the Article 21. So that aspect we have to write. Here, what happens in the analysis section, we have to analyze both the things, what the concept of constitutional law as well as the concept of administrative law. Both the administrative law and the constitutional law, the concepts has to be appreciated under the application. Here we have to write the facts of the case and we have to discuss whether special courts are properly constituted, whether there is any arbitrariness is there, or whether it satisfies the test of reasonable classification. That means I have told you what is meant by classification. So if it satisfies the reasonable classification and it satisfies the every test with regard to the Article 14 which imbibes, then we cannot say such transfer is illegal. So in this regard, we have to highlight certain decided case laws. A.R. Antule versus R.S. Naik. What has been provided here? The Supreme Court held that trial before a court not authorized by law violates Article 21. If it is not authorized by the law, then it violates the Article 21. Here what happens? Here there is statute is there. In Yesh's case, statute is there. Here the statute which says with regard to the transfer of the case from regular criminal court to special courts. Here, that aspect we have to highlight. Here, it is authorized by the law, so we cannot say it violates the Article 21. Likewise, in the Special Courts Bill 1978, here also the Constitutional Bench upheld the validity of special courts. Here, the validity of special courts has been challenged by the Yesh. Here also, the validity of the special courts has been challenged in the In re case. So here, it has been upheld by the Constitutional Bench. It says that the classification is valid under Article 14 if it is based on the intelligible differentia. So what is meant by intelligible differentia? That aspect I have told you. That is, intelligible differentia is nothing but it is a reasonable basis, rational basis for distinguishing the cases. Here there should be some intelligent decision should have been taken, and which serves as the rational nexus with the object of the law. That means what is the object? It is the speedy justice or speedier justice. So that intelligible differentia, that is the classification, that reasonable classification which is based on the rational basis is we should have the rational nexus with the object of the speedier justice. And this aspect has been reaffirmed in the KR Singh versus Union of India. So here speedy trial is an essential part of Article 21, and special courts for ensuring prompt justice do not violate fundamental rights if due process is followed. So all these things we can write in the rule of law as well as in the application part. We can write there also. And we have to discuss in application part or analysis part what we have to discuss. We have to discuss the facts of the case, and we have to discuss the issue, and we have to discuss the rule of law, and we have to analyze totally. We have to discuss the case law. So all these things we have to discuss in the analysis section. Then on the basis of this the analytical look, we have to give the conclusion. Here conclusion what we can give: Yes is unlikely to succeed. There are remote chances of success by the Yes, because it is a valid legislative framework is there, rational objective is there, and it does not violate the Article 14 and 21. And here all the safeguards are followed. So hence the establishment of special courts and transfer of the cases is constitutional one. And transfer of cases is constitutional one. And Yes's challenge will fail unless he proves malified intent or violation of the principles of natural justice. He cannot show the malified intention because his case only not transferred. The cases of the Yes's all the cases has been transferred from the regular criminal court to the special court. So there is no violation of the natural justice.